On the two first questions, the first question on the European Parliament resolution, and I suppose you're referring to the paragraph 8 of the resolution, which, as you can imagine, we have looked carefully. We will, as I've said, well, first of all, in the institutional system, the Commission has negotiating directives or guidelines which are given by the Council. And these are very clear about what I've said about respect of the acquis. So the answer is yes, we will respect the acquis. I'm sorry?
Sorry, the question was, will you respect what the Parliament asked for?
Well,
will you respect the acquis?
If you allow me to answer what I want to answer, which is that we'll respect the acquis. If there was a resolution which would go beyond the acquis, would you like us to respect it as well? I suppose no. We have to be bound by, on one hand, our existing legislation, because the Commission is guardian of the treaties, and on the other hand, to our negotiating directives from the Council. So we will respect that. As your second question is regarding, I'm not sure I understood the details, but it was about leaks, and as a principle, as you can imagine, we don't comment on leaks. So I don't know which leak it was, but we don't comment on it. If you want the truth is here. It's what the presentation I've given, and if you have any questions on that, you are most welcome. But we will not comment on leaks. I'm not sure I understood the question on human rights, because as far as I know, it's absolutely not touched in ACTA, and as you can imagine, because in Europe, of course, we are a member not only of the Human Rights Convention, but we have a lot more statute to protect human rights, but also privacy and data protection, which goes further than strictly speaking human rights, torture, etc. We will respect that again, and absolutely, and it's mentioned specifically in our negotiating position that we're referring to that. Any other question? Yes.
Maurice Wessling from the Dutch Consumentenbond, Consumer Union. You have said that in the ACTA negotiations you will request for a disclosure of negotiating documents. What will the Commission do if this request is denied? And secondly, the European Parliament in its resolution has urged the Commission for a impact assessment on fundamental rights. When can we expect that assessment, and how will it be timed inside the ACTA negotiations?
On the first question, which is a hypothetical question, if the New Zealand round doesn't lead to consensus on releasing a document, I can only say we shall see. Obviously we'll have to report. This would be very bad news from our point of view, but we shall see. There are several options envisageable. But I think it's a very important question, and clearly for us it is important that we can demonstrate, as I've said, that we do what we say, as just like I've said what we do. On your second question on impact assessment of fundamental rights, it is difficult to organize that before having the framework of the treaty, because obviously the questions on what to assess will be different. And since we are not yet there, it's difficult for me to give a timing on this. Yes, in the back. Gentleman with the blue shirt.
I just want to this is Erik Josefsson from the Green Group. I'm an advisor to the group. If you could explain a bit more about point 9, not point 8, the Commission's view on the Parliament's request to limit the negotiations to counterfeit only. I think you were not very clear in your answer to Mr. McNamee, where you repeated that you will not go beyond the acquis, which was not the question. The question was whether you would respect the Parliament's point 9, sorry, to limit the negotiations to counterfeit.
Sorry, I think it's a misunderstanding. Point 8 is on counterfeiting. Point 9 is on copyright enforcement and acquis communautaire. And I mean, I can reconfirm that we will be fully in line with the acquis, but I suspect this is not what you want to hear. No, so what exactly is the question?
Sorry, it's point 9 in the resolution adopted. Calls on the Commission to continue the negotiations on ACTA and limit them to the existing European IPR enforcement systems against counterfeiting. That is point 9.
That's point 8 actually, but...
then we have different versions here.
I pretty much have the official version of the Parliament, but okay, it doesn't matter. I mean, the reference is not important. I think actually if you read the 9, which I don't know, perhaps is the 10 in your version, it should answer your question, because you have the Parliament writing urges the Commission to ensure that enforcement of ACTA provisions, especially those on copyright enforcement procedures in the digital environment, are fully in line with the acquis communautaire, demands that no personal searches will be conducted at EU borders, and requests full clarification of any clauses that would allow for warrantless speech searches and confiscation of information storage devices such as laptops, cell phones and MP3 players by border and customs authorities. So, do we agree with that? Of course, totally. This is fully in line with the acquis. This is what I've even said in my early presentation.
And the previous point, if you read that?
Sorry?
And the previous point, if you read that, you don't see that there is a request to limit ACTA to counterfeit?
And how do you combine that with the next point? Because on the next point, it specified what we should do on copyright, which is to respect the acquis, and I've said we're going to do exactly that.
So that is your comment to the Parliament's resolution that it's inconsistent? Is that the point you want to make?
You said that. I didn't say that. I only said that if you read both, it's very consistent. It's simply spread on 2 paragraphs. The gentleman with a pink shirt?
Yes, just in follow-up to the question you were just asked. My name is Paul Meller, I'm a journalist, and could you just explain to those of us who are not experts in IP law, why is one legal instrument being discussed that addresses counterfeiting on the one hand, which includes things like counterfeit medicines that could kill people, and on the other hand, file sharing and copyright issues? What do the two have in common, and why on earth are you discussing them in the same context?
Well, the answer is simply that because both relate to IP enforcement or IP infringement, and because they are regulated internationally by the same treaty, which is TRIPS agreement of the WTO, to which all 150, I think, 3 members of the WTO have abided. And also there you have one instrument dealing with both, and I agree with you, of course, that the two nature of infringement are totally different. I'm not saying at all that it should be considered as the same thing. These are very different issues with different interests, etc. But from a legal instrument, if you want, point of view, they are both addressed in the same instrument, just like they are in WTO. Thank you. Any other question? Yes, gentleman with the white shirt.